And so I think your arguments or your responses to Justice Alito are all really heavily focused on the fact that what the court is actually doing is hearing evidence, that the court is actually assessing, making this determination about intellectual functioning in light of expert testimony about these things. And so it seems kind of odd to have rules that would be rigid with respect to how these particular experts are testifying or what the impact of the various scores are in this environment, I think. I mean, am I right about that? Like, part of the confusion that I'm having is that the, Alabama and the SG seem to want to remove the evidentiary aspect of this and make it into just a question of law, as though the court, without evidence, is just making this decision. When in fact, the court is hearing from experts who have looked at the test scores and all of the evidence and are testifying as to their beliefs regarding this particular legal criteria. And then the court is deciding.
Let me make 2 points in response to that, Justice Jackson. First of all, it's too late and irrelevant for me to pick sides in Moore versus Texas, but what the district court did in this case is precisely what the Chief Justice in dissent said was properly done in Texas. A court hears the evidence, all probative, relevant, and admissible evidence on both sides, and makes a determination against the standard, the Eighth Amendment standard, with whatever procedural or substantive applications that state law provides. And in this particular case, what I understand the state to be saying is, look, as a matter of Alabama law, whether you're talking about, I don't know, the overlap or the average or the median or whatever, if you don't have an actual score at 70, you don't get to, it is error, clear error for the court to hear other evidence that is probative of intellectual function, including other psychometric tests that test intelligence as well as adaptive functioning, and the fact that the guy was diagnosed as mentally retarded in the 7th grade. Of course a court should be able to determine that. There's just no warrant for this court to announce a constitutional rule binding on all states that precludes consideration of evidence that Alabama and the other states and the medical community properly considers probative of intellectual functioning.